and a very warm welcome to our esteemed panelists, the viewers, and our colleagues from BW Businessworld to the BW Legal Conclave of 2022. In this panel, we'll be discussing the advantages of choosing ADR mechanisms within the business ecosystem of India, how ADR contributes to reduce pendency of legal suits in courts, legislative suggestions to bolster the modus operandi of mediation and conciliation, amongst others. A very warm welcome to all of our esteemed panelists who are joining us today. Thank you so much for your time. I'll be starting with the first question. So, what do you think should businesses keep in mind while drafting dispute resolution clauses in their agreements? Could you give us a sense of the significance of such clauses and what kind of impact does it possibly have on the roadmap of businesses? We'll be starting with Mr. Singhania and we'll move on with a comment from Dr. Sengupta. Over to you, Mr. Singhania. So.
Good afternoon. I thank Businessworld for giving me this opportunity to share my thoughts on the. I am audible. I just wanted to check that before I start.
You're audible, sir.
So basically, normally dispute resolution clauses are called midnight clauses because businesses don't give so much importance while negotiating the dispute resolution clause than the other commercial terms in a contract. And I believe that it is very important that dispute resolution clause should be also treated like a business term of a contract. Why I so? Because if you negotiate a contract, for example, you negotiated a joint venture agreement and you thought that because the foreigner wants neutrality and you agreed for an ICC arbitration or you agreed for an international arbitration, then you may not know that if you have a small claim, say of $10,000 under the joint venture agreement, then you may not be able to use it effectively because there is an extensive cost involved in pursuing that remedy in court of law. And unfortunately, Indian courts have the law which says that, or that is the law in India, that in case you have an arbitration clause, because that is the clause you have chosen, you will have to go to international forum. Similarly, while drafting dispute resolution clauses, you have to also see what will be the nature of dispute which will come in the future. In case the dispute is not of a very high value, then you could also agree for not going for alternate dispute, but for a normal court of law. Third factor which always have to be kept in mind, that from where the parties are and what is the nature of relationship. If parties are thinking to go for long-term relationship, then I would say that in commercial interest, it will be important to keep option of mediation, conciliation first option, and then in case mediation and conciliation fails, then you can go for arbitration. But in certain cases, in case there is intellectual property dispute or there is a requirement of some injunction, some relief from court, then these clauses have to be keeping in that mind also.
Thank you so much, Mr. Singhania. I'd asked Dr. Sengupta to give us her comments on the very same.
Yeah, sure. So, the whole dispute resolution mechanism within a contract is really a separate agreement. So though it's in the contract, it's a different agreement between the parties on governing law, on what courts to approach for interim relief, what are the rules of the arbitration, and what are the governing rules of the contract. So there are many factors on this which take it outside the realm of any one country or any one speciality. In my experience, a lot of issues, a lot of arbitration time and a lot of time of the panels and arbitrators gets wasted, I would say, on figuring out factual matters. Now, these are some issues which can easily be within your dispute resolution mechanism. You can have a system where at least the facts and the technical issues can be sorted out without recourse to the legal experts. Because the job of legal experts is to interpret the law. It is not to mediate between warring parties on, who came first or who did what first. So I think, this is a new kind of a thought, I'd say, But arbitration has been it's been in a state of flux. There have been so many laws, and now recently, 2021, they are trying to make India into a center for international arbitration, which is why they have made the standards for arbitrators more flexible. Earlier, they wanted more arbitrators from India. Now they have understood that international companies may not be comfortable necessarily all the time with Indian arbitrators. So they've made the standards more flexible. So while they could come out with rules governing different aspects, such as the technical aspects. I have been in shipping disputes where we have spent hours over the issues related to detention, demurrage, the interpretation of the shipping contracts. Now, these are all very technical issues. How do you interpret a bill of lading? Who is the assigned party? Who is the consignee? What are the rules under which the port functions? So in Delhi, we were a little handicapped in that, we have to try and get people from some place like J.M. Bakshi who are conversant with these issues. These are not issues lawyers will normally study in so much depth. We have an overall view, but so I feel that these technical nitty-gritties are best experts. So instead of having an expert witness before the arbitrators, you should have a process of expert adjudication on the technical and facts. So if parties can agree on the facts, if you can have somebody adjudicate on the technical aspects, whether it is technically correct or possible, then only the legal issues or mixed questions of fact and law will move to the arbitrators. Because time is of essence in commercial disputes. There are countries where there's such a high rate of inflation that a delayed payment is with the rate of inflation, it almost becomes zero. Say if you have 1 crore you have to get from someone, and over a period of 5 to 6 years, it becomes almost nothing due to the hyperinflation. There are economies like that. So it is important to have certainty, it is important to have closure, and it's important to have time-bound redressal of differences. The current system we have, where it's an unending loop, you go for arbitration, it gets pulled for 2-3 years. So mediation, conciliation, arbitration, and then legal proceedings is a little too long. So it is better if certain issues can be conclusively finished off in a technical mediation, in a factual mediation, and only what is left comes up in arbitration. So, and then make it time bound. Once all the facts are clear, you can easily have judges sitting on it over a period of 1 month and reaching a decision. They don't get more time than that when they're sitting in court. The hearings go on, and practically it's like a couple of hours of hearings over a long period. So this is something you can easily work out if there is an intent not to use the system just to delay and extend the proceedings. Unfortunately, in tax litigation, prolonging litigation has become the department raises a lot of demands because they have targets. Okay. Customers, the assessees don't want to pay because that means they have to take more working capital loan if they pay. So it is easier to put the matter into dispute and keep dragging it along than it is to actually just arrive at a settlement and pay up. So this sort of thing you have to stop. We have too many people. We have an overburdened court system, and we need to have time-bound redressal of disputes, because justice delayed is justice denied.
Okay. Thank you so much. Thank you so much for your response. For the next question, I'd invite Senior Advocate Pramod Dubey and AOR from the Supreme Court of India, Mr. Siddharth Batra, to give us the responses, please. So my question to you is, what are the specific advantages or disadvantages of choosing any one particular mechanism of ADR over the other? And could you specify any factors that should be considered in this matter? Over to you, Mr. Dubey.
Thank you so much, and thanks to all the panelists and Mr. Batra, Mr. Singhania, and Dr. Sen Gupta. So far as this ADR is concerned, there was a old history and old time. There was only one way to go for the litigation. That was the litigation through the court and judges and the juries type of the concept. Slowly, the society developed, and this ADR came, like arbitration, conciliation, mediation, and your litigations. So the advantage in ADR over this litigation is concerned. You see, in the litigation, you have to follow the procedure established by a long procedure like a CPC. Suppose you have to file so many things, pleadings, so there is a time bound there, then you can do so many things. So there is a long way to travel, and there is a lot of pendency in the civil litigation if you are going. And in the civil litigation, the main thing, you have to prove your case as per the Evidence Act. This is the one thing. In ADR, you don't need to prove the fact by putting a stricto sensu the Evidence Act. There is a rule of prudence and the rule of evidence, not the Evidence Act. And in ADR, the main advantage, the party has the freedom to choose their own arbitrator, mediator, and conciliator. Not only that, in ADR, there is a practice is going on, it's developing the pre-litigation mediation. If you are anticipating any kind of the litigation, so you can write to the other party, no, we are ready and willing to settle this dispute, and we should not go to the court of law. So this is the one aspect. The second aspect is that you are choosing the arbitrator who is expert. You are choosing the mediator who you are having the confidence in, and the conciliator. So these are the things. And in mediation, the role of the mediator is to basically facilitate the two parties or more than two parties to sit on a platform, sit at a table, and resolve their grievances by discussing and resolving all the things. In arbitration, there is a clause and there is a statement of claim, and then the counter and reply, everything. And in arbitration also, you can choose the person who is expert in that. He has the technical knowledge about the subject. Like if suppose there is an NTPC matter or power grid matter or aviation matter, so you have the remedy to go with the expert. So this is the second thing. Third thing is the ADR is the cost-effective process. Unlike the court. In the court process, you are filing the court fee, you are hiring the lawyers, every day the lawyers are going, there is a lot of pleadings going on, effective, non-effective, so many things. So you can minimize the cost also. And in the mediation, you can maintain the confidentiality. If you are not consenting to the mediator to publish the public at large, your whatever the discussion was, the privately, that would be the confidential. So these are the things. And I have the experience, I was doing one arbitration in the LCIA, and it was very interesting. Every slot was booked. You by this time, you file a counterclaim, then you reply, and the rejoinder, exchange of the documents. And these are the time slot you have to start the opening argument, closing argument, then the cross-examination. You have to cross-examine the witness in particular time. So in 1 week, the entire proceeding took place, which is unlike in the common litigation. Common litigation, sometimes you find that there is a strike, there are judges is not there, other parties asking for the adjournment, so many things. Then you go for the paying the court fee. These are the basically advantages. So far as the disadvantages are concerned, sometimes you'll find that there's a biasness in the arbitration. The arbitrator is biased, then you have only remedy to go for first you move the application before the arbitrator, you recuse yourself, if the arbitrator is adamant, no, I'm not going, then you have to approach the court of law. The second thing is that if the arbitration is passed and we are not satisfied with the arbitration award, then you are going to the court, and then the court will say, no, you have very limited scope to challenge the arbitration award. First, you show us the following criteria. Even in Delhi High Court, you'll find that these days it's a very difficult to get the notice issued in the appeal against the arbitration award. These are the basically the disadvantage. And third thing, in so many arbitration proceedings, I have already mentioned these are the advantages, but we are coming across the cases where the arbitration proceeding, nothing is going on, only the parties are going and it's a 10-minute discussion, the matter gets adjourned, and you are paying the hefty amount to the arbitrator also. They are raising the bill and the lawyers are also raising the bill. So these kind of the things also going, and it's a burdening the litigant. It's a burdening the litigant. This is also the disadvantage.
Thank you so much for your response, sir. I would invite Mr. Siddharth Batra to give his response on the same, please.
Good afternoon. First of all, it's such a pleasure to share the stage with Mr. Singhania, is always smiling, Mr. Dubey and Madam Tamali. So thank you for inviting me. I'll just join with what Dubey said. He also described in detail as to in ADR about arbitration. If I ask myself a question over the years, it's an alternative dispute resolution that you don't have to go to the court. That means you'll have to have some other way. I think the only formal way till date in our country is the Arbitration and Conciliation Act, which provides for arbitration and conciliation. The mediation bill, in fact, we've heard our Chief Justice as well. He also mentioned some time back that there's need for mediation. So that mediation 2021 bill is on the anvil. In fact, I was going through the newspaper yesterday. Some comments and some objections and suggestions have been invited by the Ministry of Law as well for the mediation bill. As far as arbitration is concerned, as Dubey was mentioning that, it's a different process. It's sometimes easier than the courts. I think one star point which I take from the Arbitration and Conciliation Act is the amendment that was brought in, wherein it was said that arbitration proceedings have to conclude within 1 year. If you ask me, that's been a revelation when it came to arbitration, because arbitrations also had been pending for years. And now with the coming of this outer limit, it has changed it to a great extent. But then coming back, after the passing of an award by an arbitrator, what happens is that you file a section 34. The problem I see is in that is that those have been pending for a long time as well. And once there is a pendency, then there's a difficulty in getting those executed as well. So that is also taking in effect a lot of time, if you ask me, on the practical aspects. Yeah, it is right that you can have an arbitrator who is an expert in the dispute which has arisen. He may be more equipped than a judge that we have in the court. But having said that, if you ask me, the success of arbitration in our country, if I have to measure that, I'm not too bullish about it as to what has happened. Some more work needs to be done on this space. Mr. Dubey was right in saying that as far as getting a notice issued after an award is concerned in 34, you go to the High Court does not issue notices. But I personally experienced that even pendency of that 34 without issuing notice, the awards are not being executed. The jurisdiction of a court after passing of an award is very, very limited. There are points which have been given. That needs a strict adherence. And every now and then there are judgments of the Supreme Court coming. Even there was another latest judgment which has been written by Justice Ravinder Bhatt. I was reading the same. They have mentioned it that even if the arbitrator has gone wrong on some issues, that cannot be ground in a 34 to set aside the award. But how it has to be followed? I give you another example that there's an arbitration award wherein there are 3 Supreme Court judges gave an award, and it's a huge award for a company. Now the 34 against that will go to a district judge. So 3 Supreme Court judges, retired Supreme Court judges, making an opinion on an award, and then it goes to a additional district judge or district judge. That rigor is taking some time. I think that needs to be seen. if you see the other part, which I mentioned, conciliation, if you ask me, conciliation has failed in our country. I have personally not come across any case wherein conciliation was agreed and there was some settlement which came out of conciliation. That has completely failed. And regarding pre-mediation, if you see, there's now an amendment in the Commercial Courts Act as well. If you file a suit under the commercial courts, before the commercial courts, there's a pre-mediation. You have to mandatorily go for that mediation. And if that mediation fails, and then you can file. That has already started. So changes has started to come, that because there's a lot of pressure as far as courts are concerned in our country. And a lot of times, as Madam Tamali also was saying, that justice delayed is justice denied. But one fact which I always ask myself also, that why there's delay in our country. You can't compare our country to the judicial system that is in the UK or the US, because look at the number of cases. Over here, considering our population, the number of cases that we have, I can say one thing, that our high courts are doing a great job. I mean, for a judge to read, say, about 70 to 100 odd cases every day and try to decide them, I think there's a magnitude of effort which is being put by the superior judiciary, I can say.
Okay.
Even with that, I will conclude. Yeah.
Okay. Okay. Thank you so much for your response, sir. We'd go back to, we'll proceed with the third question, and we'll go back to Mr. Singhania for his response to it. So are there any specific ADR mechanisms that is more suitable for certain type of disputes or industries? And can you give us a sense of how appropriately this allocation of ADR mechanisms is made? Over to you, Mr. Singhania.
No, my view is on this subject that in case there is a contractual matter, then parties have a choice whether they want to go for arbitration, mediation, or conciliation, or go for litigation. Because depending upon the nature of dispute, in case it is merely a monetary claim, then the matter can be decided by arbitration and parties can choose. Particularly where, for example, in construction industry, they need people who have technical knowledge in case there is a dispute between the parties to be resolved. In that cases, they can have an arbitration clause or mediation clause, so that first there is a conciliation approach. Secondly, they also have to keep in mind that the project which is undergoing in construction, that should not get affected while dispute is going on. And the third factor there is that the technical person qualification can be also mentioned in arbitration clause, because that is the clause written by choice. So that could definitely help those type of industries where there is a technical element and the claims can be large. But in case the claims are not of large nature, then I would say arbitration is not an effective tool, because it's also time consuming, and it also affects businesses while they are going on, because somebody has to spend their time. Because one thing which is now important we should understand, in the developed world, they are looking at not only that they are afraid to lose a case, but they are also looking at their management time. How much time management has to spend looking after all these disputes. So it is important to know that parties by agreement also can put a time limit also in case there is a dispute, how to resolve it, and they can put everything in the contract. Second aspect is that if there are certain contracts which you cannot arbitrate, because if it is a criminal nature or it's a fraud or there is something which courts only can decide. And already in Indian Arbitration Act, there are specific cases which cannot be decided by courts, by arbitrators, so that matter has to go. Like, for example, if there is a legal license, even though we provide for arbitration in that, but there is a gray area. Sometimes courts say, no, courts have only exclusive jurisdiction. In case there is a dispute about the title or about the removal of the tenant from the premises or licensee from the premises, then only court.
Thank you so much, sir. Thank you so much. I'd be moving on for a response from Dr. Sen Gupta on any suggestions or whether a standalone law specifically focusing on mediation or on conciliation is required in India. Over to you, Dr. Sen Gupta.
Yeah, so in my view, I think what I'm suggesting is a bifurcation where all the facts and technical aspects get taken in mediation, and legal matters only go to arbitration. The reason for this is, there is this attitude in India that I'm okay, you're not. So everybody believes they are right, everyone else is wrong. Maybe this is a product of our democracy, maybe it's a product of entitlement, who knows? But in any civil society debate, and we have seen many of them over the last couple of years, there are almost no flexible stands. There is one group trying to shout you out for being biased, parochial, secular, not secular, fundamentalist, whatever it is. So bottom line is, I don't think we can rely. The nature of our society is such, is there's a lot of noise, which requires people to be right at all times. So they are not in a conciliatory frame of mind. So conciliation and mediation only work if you are in the mood to conciliate or mediate. But if you get sound bites and mileage from opposing, and that is, glorified more than settling issues is, then there's no reason for you to do that. So therefore, I would suggest that we strictly demarcate between the legal and the non-legal aspects, have experts determining the non-legal. I would even go to the extent of saying that in a contractual dispute, in a long-standing contract, they should have an exchange of timelines from time to time, which is agreed by both parties. That will save a lot of effort on disputing versions later. So for instance, every beginning of the year or end of the financial year, you say, okay, this is the contract, these are the timelines we've adhered to.
Okay.
And these are the reasons. So
Okay.
on an ongoing basis, at least you are in agreement on some matters. Otherwise, everything becomes a subject of disagreement.
Okay. Thank
So,
you so much. So I've been told that we are running a little short on time. The next panelists are also here to start with the next panel. So I'll just ask for 1 minute brief inputs quickly from Mr. Dubey and also from Mr. Batra. So my final question would be that, despite, of course, the significance of courts, and of course, litigation can never happen without courts, but yet still, what do you think is the significance of ADR in the business ecosystem? So I just ask for 1 minute brief inputs, first from Mr. Dubey and then from Mr. Batra.
One thing must be understood, that ultimate goal of any litigation, any dispute is the dispute resolution. Now, during the various stages, the party may approach the court for the enforcement or the adjudication of their right, but that does not vitiate the advantage of ADR. ADR has proven to reduce the burden and be cost time effective. So what is the need? Need to work on enforceability of the award and taking a more adaptive approach towards the ADR.
If you ask me, ADR obviously is one of where we have to look in, because as we said, dependency of a lot of cases in the court, alternate dispute resolution has to be aggressively looked into. But yes, we'll need more changes in the law that we have right now. Obviously, we're coming up with a mediation bill as well. Let's see how it goes, and it's the right step in the right direction. And I personally have a lot of expectations that once the mediation bill comes in, there will be a change which will be brought in the mindset to go for mediation before approaching the courts.
Thank you so much. Thank you so much to all of our panelists who joined us today. We've spoken about some very imperative structures and developments in the ADR mechanism. We thank you for joining us and for giving us your time. Over to you, Aditya, to take up the next panel. Thank you so much.